Constructive dismissal. We've all heard the term, but what is it and what does it actually mean? I sometimes get questions from employees regarding what kind of conduct at work may amount to a constructive dismissal. And these are fair questions because these situations are highly fact-driven. Typically, for a constructive dismissal to result, it must involve some conduct by the employer that falls into one of two categories. Category 1, which is by far the most common category, involves a substantial breach of or change to an essential term of the employee's contract, usually their compensation or their duties and responsibilities. Category 2 is a little bit more tricky and involves some conduct by the employer indicating that the employer no longer intends to honor the original terms of contract. In one recent case, the court found a constructive dismissal where the employee was demoted and thereafter forced to report directly to the new hire. The court called this a marginalization of the employee's duties. In yet another recent case, the court found a constructive dismissal where the employer demanded the employee sign a new employment contract with significantly harsher terms. In both cases, the employees were awarded damages in a manner no different than if they had been explicitly terminated. Remember, timing matters. Employees have three options available to them. They can accept the change and continue working under the new terms. They can reject the change and insist on the original contract terms. Or 3, if the employer persists, they can reject the change, resign, and claim damages in a manner no different than if they had been explicitly terminated. If you have questions about constructive dismissal at work, contact Evolution Legal for an assessment of your matter.